All right, well, thank you everybody for joining us today. I know we're very close to the holidays, so I appreciate everybody taking the time out. We're going to start with talking about our privacy law review. I'm just going to give it a few more seconds as we have a few people joining us. All right, so let's get started. I'm Parna Mehrbani. I'm a partner at Tonkon Torp in the intellectual property group, and I'm also the co-chair of our privacy group. I'm hoping for no internet problems today, but I've been having a little bit of trouble this morning, so bear with us if there are problems. Hopefully everybody can see the screen. You can also, if you have questions, use the Q&A, and we will answer those questions either directly to you in the Q&A or in the presentation. Please feel free to use that freely during the presentation, or there will be hopefully time at the end for questions as well. I want to thank my colleague Eric Beach, who helped me prepare for this presentation, and who many of you may know from our privacy group and from our prior presentations on the various topics in the privacy space. So today we're going to talk about 2020 updates in privacy law. We will cover California Consumer Privacy Act regulations. We've done a few other educational sessions on the California Consumer Privacy Act. We're going to try not to duplicate those prior presentations. So if you do have questions about the general terms of the CCPA, as it's known, please let us know in the Q&A, or we can follow up after the presentation. We're also going to talk about the new California Privacy Rights Act, which was passed by voter initiative on November 3rd. We're going to briefly discuss proposed Washington legislation, potential for Oregon legislation, and then a few City of Portland ordinances on facial recognition. So to start, the CCPA regulations, these were finalized in July of 2020 by the California Attorney General. The regulations attempt to flesh out the details of the CCPA that weren't specifically covered in the statute. And as many of you may know, that statute took effect January 1st of 2020. So the key issues in the regulations cover the details of the notices that you have to provide to consumers. So the notices at collection, that's when you collect their data. Notices of the right to opt out of sales of their data, notice of financial incentives that may be attached to consumers providing their data to you, responding to consumer requests, and then training and record keeping. The regulations are very dense, and so to the extent we can't cover all of the specifics today because it's just really specific and really fact specific in a lot of instances. So we'll try to cover the big picture. And then again, if you have follow-up questions, we're happy to talk to you after the presentation. So this slide covers what's required of all of the notices that you provide to consumers. And it's pretty understandable, right? The notices, the basics are that every business must have a privacy policy. A business that collects personal information must provide notice at the time that you collect the personal information. And if you sell personal information, you have to provide notice of the right to opt out of sales. And then if you offer a financial incentive to a consumer for disclosure or sale of their personal information, you have to disclose the particulars of that incentive. So you'll see I have an asterisk next to a few words on this slide, and you'll see that in a few other slides. Those asterisks mean that those are defined terms in the California Consumer Privacy Act. I'm not going to, again, go into the nitty-gritty details of those definitions today, but personal information is specifically, they have a list of what's included in that, and we just refer to it as PI today. Sales is really broad. It doesn't necessarily just mean handing over information for money. It's a broader disclosure. And then a consumer is limited to folks in California. So when we say consumer as part of these California statutes, we mean California consumers. So all notices and your privacy policy, these are the things I said are pretty understandable, right? You have to use straightforward language. You can't use a lot of technical or legal jargon. They have to be in a readable format, and that goes to sort of the actual font size and format of the link or document on your website or on a mobile app. So it has to be readable on small screens. You have to provide the notices in all languages that you use in the ordinary course of your business. And then this is an important one. It has to be accessible to consumers with disabilities. And on this, the regulations point specifically to the Web Content Accessibility Guidelines version 2.1. So those guidelines are created by an independent organization, but have generally been accepted as the guidelines to use to make websites accessible to people with disabilities, including people with visual impairments. So it's interesting that the California Attorney General is pointing to that, because that's kind of become a general standard, even though it's not regulatory. It's just a third party's guidelines. So notices at collection. So this is when you collect a consumer's information, which most often happens on your website, right? You're collecting data about the users on your website, or you're collecting information about folks that buy things from your website. So on your website, that notice at collection has to be on the home page and on every single page where information is collected. So putting it in your footer that shows up in every single website page is probably the best idea. For mobile apps, the notice has to be provided on, or a link to the notice has to be provided on the download page and within the app. So for example, on a settings, in the settings menu. If you collect data from consumers offline, you have a few options. You can print the notice on the form that the person fills out to give you their data. You can hand out a copy of the notice, again, on paper, or you can have prominent signage or a prominent notice on that piece of paper that provides them with a link to where they can go to see the notice on your website. If you collect data from people over the phone or in person, so for example, if you take orders over the phone, you can provide the notice of collection orally, so as you're speaking to them. And then finally, if you're collecting data via a mobile device for an unexpected purpose, like for example, if you're using a flashlight app and that flashlight app is collecting geolocation data, that's an unexpected purpose of a flashlight app. So that requires what the regulations call a just-in-time notice. For example, a pop-up window when the person opens the app. The notice of collection must include the categories of personal information about the consumer that you are collecting, the business purpose for that collection. If personal information is sold, it must include a do not sell link. And then a link to your privacy policy. So all of this information may be in your privacy policy. And so when you provide this notice, it can be in the format of your privacy policy itself. If you're collecting employment-related information, specifically for employees, you do not need to include the links to the do not sell or links to the privacy policy. You just need to provide notice that you are conducting the collection. So for your notice of right to opt out of sale, the format of this, again, it only applies to businesses that sell personal information under that very broad definition of sell that we've talked about in our prior presentations, and that is part of the CCPA. If you don't sell consumer information, you can just say that in your privacy policy, and then you don't need to provide this additional notice. If you do sell consumer information, again, on your website, you have to have a link that says, do not sell my personal information. That link must appear on your homepage. On a mobile app, again, it must appear on the download page as well as within the app. So on a settings menu, for example. If you have substantial offline interaction with consumers, so again, maybe you have stores or other offices where you have interaction, you have to print the notice of right to opt out either on the forms, again, where you collect the information, you have to hand out a piece of paper that gives them the notice in writing, or again, prominent signage with a link. If you have no website, then it is up to you as a business to establish, document, and comply with another method that sufficiently informs consumers of their right to opt out. So that's sort of a catch-all. The content of that right to opt out, again, must be a description of the right. And if it's on your website, it must be an interactive form by which consumers can either submit the request to opt out online, or if you don't have a website, it must describe the offline method by which the consumers can submit their request to opt out. And then you can also provide instructions for other methods by which consumers may submit a request to opt out. So I think the big important thing here is really that if you have a website, the regulations say that you have to have an interactive form that can be filled in by consumers. So notices of financial incentives. So this only applies to businesses that offer a financial incentive or a price difference or a discount of some sort that relates to your collection, retention, or sale of personal information. So if you provide any of those sorts of things in exchange for the consumer's personal information, you have to provide that notice readily available where a consumer will encounter it before they opt into that incentive. On your website, this can be via a link to your privacy policy. The content of this notice of financial incentive has to give a summary of what the financial incentive is, the price difference or the service difference that they're going to receive if they do or don't opt in to the financial incentive. And then the material terms of it, including the categories of personal information that are implicated by that financial incentive. And then instructions on how the consumer can opt into that financial incentive, and a notice that the consumer is permitted to withdraw from it and how they would go about withdrawing from it once they've opted in. And then, and this is an important piece, which is the explanation of how that financial incentive or the price difference or the discount is reasonably related to the value of the consumer's data. The regulations do have some guidance on how to value consumer data, which we're not going to get into today, but I mention it because that's a question we get a lot on, well, how do we know, how do we put a price on what the value is of that consumer data? So as I think everybody knows, you're required to have a privacy policy under the California Consumer Privacy Act. The privacy policy must be posted online through a conspicuous link using the word privacy. It has to be linked on your website homepage. If you have a mobile app, it has to be on the download or landing page. And you can also include a link in your settings menu. If your business has a California specific privacy notice, then the privacy policy must be included within that California specific notice. So again, those can be linked between the two, but the privacy policy has to be included in that California specific notice. If you don't have a website, the privacy policy has to be made conspicuously available to consumers. So again, that might be handing out paper or in some other way that you communicate with your consumers. I think it would be hard to do it orally with a long privacy policy, but so a paper handout is probably the most practical way to deal with that. So the required content of your privacy policy, you have to explain to consumers the right to request. This is a right to know, essentially. You have to explain that the consumers have a right to know. They're allowed to ask what personal information the business collects, uses, discloses, and sells. You have to provide in your privacy policy instructions for how to submit the request to know. So how does the consumer go about submitting a request to get this information from you? You have to describe the process that you're going to use to verify their identity, to verify that request. including any information the consumer has to provide to you in order to verify that request. We'll get a little bit more into verification in a few minutes. Your privacy policy also has to include the categories of personal information that you have collected about consumers in the past 12 months, the sources of where you got that personal information, and the purposes for either collecting or selling the information, if you do sell it. And finally, the categories of personal information that you have disclosed for a business purpose, or which you have sold to third parties in the past 12 months. And then the categories of third parties to whom the information was disclosed or sold. So that's a lot of information. It is all required to be included in your privacy policy. You also have to explain the consumer's right to request deletion. So the right for deletion is another right that's given to consumers in the CCPA, and you have to explain to consumers in your privacy policy that they have that right. Instructions for how to submit those requests, the process you're going to use to verify those requests. We've covered this already. You have to tell consumers whether you sell or don't sell their personal information, and then an explanation of their right to opt out of the sale. And then finally, the last pieces of information that are required to be included in the privacy policy are explaining the consumer's right not to be discriminated against by the business for exercising the privacy rights that they are given in the CCPA, instructions on how a consumer can use an authorized agent to make various requests on the consumer's behalf that are allowed under the CCPA, contact information if the consumer has questions or concerns about your privacy policy, and the date that the privacy policy was last updated. All right, so consumer requests. Again, we're still in the umbrella of the CCPA regulations. So the methods for submitting consumer requests. So when we first started talking with clients about the CCPA, there was lots of questions on like, how do we go about accepting these requests? What do we do with them? How do we verify that people are who they say they are? There's a lot of detail in the regulations about this. So again, we're just going to cover some big picture items today. So for requests to know, you have to provide, if you are an online only business, you have to provide an email address where people can submit a request to know. Other businesses have to offer, let me back up and make that clear. If you are online only, which means no other methods of interacting with consumers, then you can only provide an email address. If you have an online presence plus other interactions with consumers, again, like stores or offices or anything like that, you have to provide 2 or more methods, including at a minimum a toll-free phone number. For requests to delete, you have to provide 2 or more methods by which consumers can submit requests to delete. So that might be email, that might be a toll-free phone number, it might be mailing in forms. And you are permitted to use a 2-step process for online requests. So that means you can have a form where someone submits an online request, and you can send an email that says, we received this request. Please confirm that this was you that submitted it. So it's okay to have that double the 2-step process for requests to delete. For requests to opt out of sale, 2 or more methods are required. So you have to give consumers at least 2 different ways by which they can submit those requests. You must have an interactive form on your website. So you have a do not sell my personal information link. That link needs to go to a page that has all the required information and that we already talked about. And there has to be an interactive form that's accessible from that link. It has to be easy and require minimal steps. There is a reference in the regulations that user-enabled global privacy controls. So for example, browser plugins or other device settings. If you receive those communications that communicate to you that the consumer wants to opt out, you must treat those as a valid request to opt out. And then there's this overarching statement that businesses must consider how you primarily interact with consumers when you determine the methods for submitting requests. So if you have no other interactions with your consumers that happen by regular mail, then using regular mail for submitting these types of requests may not necessarily be the best choice, because that's not how you primarily interact with consumers. For responding to requests, for requests to know, so what information you collect, and requests to delete information, you must confirm receipt of the request within 10 days, and you must respond within 45 days. That 45 days does not include however long it takes you to verify the consumer is the consumer that's making the request. There is a possible 45-day extension to that response timeline, but you have to notify the consumer that you need that extra 45 days. If you cannot verify the consumer's identity within 45 days, you can deny a request. For requests to opt out of sale, you must respond within 15 days. So this is where just a note that the obligations for responding to requests differ based on the type of request that's made, what information can be verified, what information you have about the consumer, the reasons you have that information, whether consumers have a login account with you, and other different very fact-specific scenarios. So again, rather than getting into all those nitty-gritty details today, we're happy to talk with you about your specific circumstances offline. Okay, so verification of consumer requests is still a pretty muddy topic. You are not permitted to disclose information to the requesting person or requesting consumer without verifying who they are. You also cannot delete information without verifying who they are. So you have to, businesses have to establish, document, and comply with, this is a quote, reasonable method for verifying that the person making the request is the consumer whose information you have. There's a lot of factors in the regulations to consider. Again, the process may depend on what you have, why you have it, and whether the consumer has an account with you. Again, it's a really fact-specific, so we can't go into all of the details today. In general, you should not ask for more personal information in order to verify who the person is. But in some circumstances, you may do so if the identity of the person, there's a typo there, sorry, if identity cannot be confirmed from the information that you have. You're not allowed to require a fee for any of these requests or taking any of these actions. And just a note that authorized agents may submit requests on behalf of consumers. And there are specifics in the statute as to what authorized agents have to provide you in order for you to confirm that they're authorized to act on behalf of the person that they say that they're acting on behalf of. Okay, so training and record keeping is also covered by the regulations. All individuals responsible for handling CCPA requests must be trained on the requirements and how to assist consumers in exercising their rights given to them under the CCPA. You must retain records of all consumer requests that you've received, as well as your responses, and you have to keep those records for 24 months. The records must be securely maintained, and you have to include in your records the date of the request, the nature of the request, the manner that the request was made, the date of your response, the nature of your response, and if denied, if you deny the request, the basis for denying that request. And then those records that you're keeping can't be used for any other reason except for monitoring compliance with the CCPA. So you can't keep those records sort of with the data that the consumer may have asked you just to delete. There's additional regulations that apply to businesses that have information on 10 million or more California consumers, which include metrics and reporting and things like that, which again, we're not going to go into today. So just a quick note that some of you may remember that there were lots of concerns about how the CCPA applied to employment data and business-to-business data. And then there was an exception, an amendment to the CCPA, making an exception that many of the provisions of the CCPA do not apply to employee data or to business data. That exception has actually now been extended as a result of the California Consumer Privacy Rights Act, Privacy Rights Act, which we're going to get into next. So these exceptions are now extended and they expire on January 1st, 2023. For workforce and employment related personal information, the only things you have to do are the notice of collection. So you have to tell employees when you're collecting data about them. And the employees continue to have a private right of action for data breach, which applies to everybody. So all of that other stuff, the request to know, the request to delete, the request to opt out, none of that applies to employee data. And the slide specifically lists what workforce or employment related data covers. So it's job applicants, employees, owners, directors, officers, etc. The business-to-business exception applies to communication or transactions between your business and a natural person who's acting in their capacity, again, as an employee, owner, director of another entity. And this, those people can still take advantage of the right to opt out, the non-discrimination obligations, and again, the private right of action. But all of those other notices and requirements of the CCPA don't apply to the B2B communications. Okay, that is it for the CCPA regulations. I know it was very dense and a lot of information. If there's any questions, you can put them into the Q&A now, or we can answer them at the end. And again, you can always reach out to us after the presentation if you have specific questions about your business. Okay, so the California Privacy Rights Act, this was just passed on Election Day, November 3rd. It is not a standalone law. It is an amendment to the CCPA. So a lot of what we just talked about may change. The CPRA, the California Privacy Rights Act, is scheduled to begin, it goes into effect January 1st, 2023, but it applies, it has a look back. So it applies to all data that was collected on or after January 1st, 2022. So we have some time with this one, but this is just anticipating what's coming. So the CPRA, one of the big things that it does is it establishes the California Privacy Protection Agency, which is going to take over, or under the terms, is going to take over rulemaking from the California Attorney General. This may be in response to the fact that after the CCPA was passed, the California Attorney General made it pretty clear that they didn't have the resources to pursue enforcement. At one point, the California Attorney General suggested an amendment that essentially said that they didn't have to write any regulations. That amendment did not go through, but my perspective, the California Attorney General was pretty vocal that they didn't have the time or the resources to implement the CCPA. Rulemaking for the CPRA will begin as early as July 1, 2021. And final regulations are required by July 1, 2022. So we will have more information to come. Enforcement will begin no earlier than July 1, 2023, and applies only to violations occurring on or after that date. So July 1, 2023 is really the big trigger date. There is a pretty interesting limitation on amendments. So the CPRA can be amended to be more protective of privacy, but any amendment that attempts to remove privacy protections can only be done by initiative by the voters of the state of California. So this really limits the legislature's ability to take away any of the rights given by the CPRA. Okay, so the CPRA gives additional rights to consumers beyond what's in the CCPA, and it places additional obligations on businesses. So they created a new category of information called sensitive personal information. So there's additional protections for that. It expands opt-out rights of consumers, and it requires businesses to provide additional mechanisms for consumers to access, correct, or delete data. The first question under the CCPA is really, who does it apply to? Well, the CPRA amends that a little bit. So it still applies to the businesses with a monetary threshold of annual gross revenue of $25 million or more in the preceding year. So that stays the same. It does change one thing, which I think will be good news to a lot of businesses, which is the CCPA previously applied to anyone who collected information about 50,000 California consumers within a year, which turned out to be like 180 some visitors a day to your website from California. Well, the CPRA ups that number to 100,000, excuse me. So it doubles the amount of information you collect from California before you become subject to its provisions. So for smaller companies, that might be good news, because then you may not be subject to the provisions any longer. It also changes the provision that applies to businesses who derive 50% or more of annual revenue from selling personal information. And it expands that to selling or sharing personal information. Sharing is a new defined term under the CPRA, and it covers disclosing personal information to third parties for cross-contextual behavioral advertising purposes. So this is, the businesses that share your information for purposes of giving you targeted ads. So when you are searching for Christmas presents or holiday presents, and just as an example, and you start looking for toys for your, grandchildren or niece or nephew, and then for the next 3 months, everything you see on the internet is for toys. That's because of this cross-contextual advertising. So CPRA expands the right to know. So for information collected after January 1 of 2022, the 12-month look-back period that is currently in the CCPA is being removed. So if you get a request in 2024, you will be required to provide all data about the consumer making the request, going all the way back to January 1, 2022. So as we move further forward in time, the amount of information you're going to have to provide to consumers is going to be greater and greater, and not limited to that 12-month period, which was what the CCPA had. The CPRA also modifies the right to delete. It modifies the circumstances under which you can deny a request to delete, which is actually probably good news for businesses. A new right that is added in the CPRA is the right to correct inaccurate personal information. So the CCPA didn't have anything like this. It just had a request to know what information you have and a request to delete it. So the CPRA adds a request to correct. And then finally, I already mentioned that we added sharing in the CPRA. And so now there is a right to opt out of sharing, similar to the current requirements where you have to have a right to opt out of selling. As I mentioned, sensitive personal information has been added as a new defined term. And there is an added right to restrict the processing of sensitive personal information. So sensitive PI is probably what you can guess it is: social security number, driver's license number, passport number, financial information, precise geolocation information, biometric and genetic information, racial, ethnic, religious, philosophical, or union membership information. Any personal information collected and analyzed concerning health or a consumer's sex life or sexual orientation, And then finally, private personal communications. So if you have a platform that allows users to chat with one another, those are considered sensitive PI. It would not necessarily cover questions and answers between the consumer and the business, just private personal communication that happens on a business's platform. So businesses that process sensitive PI will be subject to additional requirements, and consumers will have the right to limit the use of that sensitive PI. There's expanded disclosure and opt-out requirements. So you're going to have to, just like you currently have to disclose what you sell and why, you're going to have to disclose the types of sensitive PI that you collect, why you collect it, the retention period for every category of personal information collected, details about your processing of sensitive personal information, and whether you're, not only whether you sell personal information, but whether you share it under this new definition of share. And then a stated commitment not to re-identify personal information that was previously de-identified. And then, as I've already said, consumers can restrict the use and disclosure of this new category of sensitive personal information. And it requires another link, which can be combined with the current link. For right now, we have a link for do not sell. You're going to have a link for limit the use of sensitive personal information, and that can be combined in the same page with the do not sell link. And then there is, again, reference to how businesses will have to respond to automatic opt-out signals, again, that come via platforms or devices. So if a user is using a browser that sends an automatic opt-out signal, there are requirements on how you respond to those, and that's going to be subject to future regulation under the CPRA. Okay, so additional protections under the CPRA. There's a new general obligation that's sort of overarching for the whole thing, which is that businesses in their collection, use, retention, and sharing of consumers' personal information, all of that must be reasonably necessary and proportionate to achieve the purposes for which the information was collected or processed, or another disclosed purpose that's compatible with the context in which the personal information was collected. So that's sort of makes sense from a user standpoint, that your use of personal information has to have some link to the purpose for which it was collected, and compatible with the context. So again, that goes to some of the sort of unexpected information that's being collected by businesses that consumers wouldn't necessarily think is happening. There are very specific provisions in the CPRA as to what must be included in third-party contracts that involve selling, sharing, or disclosing PI. And there are more direct obligations on service providers, including specific requirements that service providers cooperate with businesses in responding to consumer requests. So if a service provider gets a request from a consumer, there are specific requirements as to what the service provider has to do and the information they have to provide to the business for whom they collected that information. And then, as I mentioned earlier, the CPRA extends the prior exceptions for employee and B2B data until the day that the CPRA goes into effect. The CPRA also requires explicitly that businesses implement reasonable security measures and practices, which are appropriate to the type of PI that they have in order to prevent unauthorized access. Some of that, again, will be subject to regulation because the terms are not all defined. Reasonable security procedures and practices are not defined. And then it requires it requires businesses, sorry, I'm looking at some questions. I'm just gonna take a second to answer. So there's a question about whether these requirements apply to things like homeowners associations. There is a limit to the size of businesses. So as I mentioned earlier, there are the CCPA and the CPRA will apply to businesses that have an annual gross revenue of 25 million or more in the past year, or if you collect the data of, currently it's 50,000, under the CPRA it will be 100,000. So if you collect the data of 50,000 or more consumers, which under the definition is California consumers. Or if you derive 50% or more of your revenue from selling consumer data, and then again, in the new provisions in the CPRA, it will be selling or sharing. So most likely, if you're a very small business, it probably doesn't apply to you, but it's not based on the number of employees you have. It's based on those three factors of either your revenue, how much data you collect, or how much data you sell or share. There's another question about setting up your browser so that you are always opting out. That will depend on your specific browser that you're using. So it's not really something that I can go into right now because it will depend on how the browser functions. But I would suggest that you look in the help setting for your browser, or I suspect if you go to the top right-hand corner of the browser, there will be a settings menu that has a privacy option that you can set your settings there. We'll tell you that some browsers, for example, that they have companies that sort of interact with data in other ways, might not have those options. There are proprietary browsers that exist that opt out, that have sort of an automatic opt out. One that I have heard of, I think is called Brave, and one is called DuckDuckGo. Those, you may try one of those. I don't know much about them, but DuckDuckGo is a browser that I think has automatically restricts what data is sent out while you're browsing. There's a question about whether the size requirements apply to subcontractors that do not directly collect the data. So this, the size requirements, the three that I just mentioned, apply to any business. If you're not directly collecting data, then I don't think you would reach those requirements. But if you are doing business with companies, they may require you to make certain representations in your contracts. So it will kind of depend on the specifics. But if you're not directly collecting data, but you're just processing someone else's data, you are probably a service provider under the CCPA, or there's a new definition under the CPRA for, I think it's for contractors. So you may fall under the service provider or contractor definition. And under those definitions, there may be contractual obligations that your clients will require you to enter into. And there may be some requirements of cooperation with folks who are subject to the CCPA. So like if you get a request, you may be required to take certain steps to notify the business that the request applies to. Thank you for those questions, all really good ones. So just finishing up the additional protections of the CPRA. The CPRA requires businesses that process personal information in a manner, that presents a significant risk to consumer privacy, to perform annual independent cybersecurity audits and to submit annual privacy risk assessments to the forthcoming Privacy Protection Agency. The CPRA continues to limit the private right of action to the data breach context. It does add certain account credentials to the subset of personal information to which the private right of action applies. And again, that private right of action is only in the context of a data breach. Okay, so the proposed Washington statute, that was a lot of detail about California, but given it's the biggest jurisdiction, and that if you do business in California, a lot of the times that's the standard that we need to follow, because you can't necessarily have different standards for different jurisdictions. It's good to be prepared for what's coming in California. I will also say that the fact that California continues to make privacy rights stronger for its citizens is hopefully some motivation for federal legislators to continue to work on federal legislation, so that we're not dealing with piecemeal legislation in different requirements and different standards in all the different states. So Washington is working on the Washington Privacy Act of 2021. This was first proposed in 2018, but I think this is the third go around. They have failed to get enough support each time, and it's due specifically in part to disagreements over a private right of action for violation of the statute. And that's, just to clarify, a private right of action is when someone can individually sue a business for violating the statute, versus like a regulator, like the Attorney General, being able to sue a business or take enforcement action against a business for violation of the statute. And obviously a private right of action is a bigger concern for businesses, because it's subject to a lot, potentially subject to a lot more litigation. So the newest version in Washington is broader in scope than previous versions, and it has specific provisions dealing with data privacy in relation to public health emergencies, and obviously that's in response to COVID. If it's passed, it will have an effective date of 120 days after enactment. So the Washington Privacy Act will, again, in proposed format, so it may change between now and it may not get passed at all, but assuming that it passes in its current form, it would apply to legal entities that conduct business in Washington or produce products or services that are targeted to Washington residents, and who control or process personal data of 100,000 consumers or more during a calendar year. Again, we'd expect that consumers to be limited to Washington consumers, or who derive more than 25% of their gross revenue from the sale of personal data and process or control personal data of 25,000 consumers or more. So there's going to be a limitation again on applicability of the Washington statute, as we would expect. The Washington draft legislation specifically exempts governmental agencies, municipal corporations, protected health information, personal data that's regulated under other statutes like the Graham-Leach-Bliley Act or other statutes that govern certain industries. And it also specifically exempts employment records. And then there's other exemptions for nonprofit institutions and, nonprofits and institutions of higher education. So the rights and obligations in the Washington Act include the right of access, right to correction, right to deletion, right to data portability, and the right to opt out of certain data processing. The right to opt out is broader than the CCPA and includes processing of personal data for purposes of targeted advertising. So this gets to the sharing concept that we just talked about in the new California legislation. And then controllers are required to conduct and document data protection assessments for certain processing activities. And those are listed there on the slide, but include processing for targeted advertising, selling personal data, processing data for profiling, etc. So enforcement, again, under the proposed Washington legislation, currently no private right of action. There's a 30-day cure period for violations, and there are fines for violations of the act currently at $7,500. And it's unclear if the enforcement can be taken against people who are just doing processing, or if it's only taken against the people who control the data. Okay, we're nearing the end, close to the end of our time here, and I know I'm going quickly. So in Oregon, there's no currently no comprehensive data privacy legislation. We have various common law torts, so common law injuries that could give rise to a cause of action, and then we have sector-specific laws. So for example, there's a Oregon law that regulates the use, disclosure, and processing of student data. We also have a data breach notification law. This is if there's a unauthorized access or illegal access to data. That was last updated January 1st, effective January 1st, 2020. That's called the Oregon Consumer Information Protection Act. There is also a provision in the Unlawful Trade Practices Act, the UTPA, that makes it an unlawful trade practice if you violate your privacy policy. So this is the reason that we strongly recommend that privacy policies are not aspirational in any way, and they accurately reflect what you're doing on your website. So you make sure that they're your privacy policy is drafted for your website and not sort of a form taken from another website, because you can be you can violate the Unfair Trade Practices Act by not following your privacy policy. So in Oregon, the Department of Justice Financial Fraud and Consumer Protection section handles privacy cases, and they accept complaints from consumers if a consumer feels that a business is violating their privacy. We also have a very vocal senator at the federal level who is an advocate of comprehensive privacy legislation at the federal level. Most recently, Senator Wyden proposed the Mind Your Own Business Act of 2019, the MYOB Act, which I think is a pretty good name for a statute. Hasn't gone anywhere, but he is definitely a vocal advocate. And then finally, the Oregon Department of Justice, under the Attorney General, has a consumer privacy task force or working group that has just up until a few weeks ago, I think in October, been working on it's not really the act, but the Oregon Privacy Rights Act is what it's tentatively called. There are initial drafts that I actually was trying to track down this morning. Those drafts are rumored to be a mix of the GDPR, the CCPA, and the proposed Washington Privacy Act. The working group under the Attorney General had sort of concepts that they were looking at. And my understanding from our colleagues who work with legislation is that the drafts didn't entirely reflect what the working group was working on. And so they're definitely still very much drafts. My understanding is that the next legislative session in Oregon is probably going to be mostly virtual due to COVID restrictions. So I'm not anticipating an Oregon Privacy Act passing in 2021. But it is certainly possible that another group, so a consumer group or an advocacy group, will submit privacy legislation that could be considered by the Oregon legislature. But if I were to look into a crystal ball, I would not expect something in 2021. But I do know that it's something that the AG's office and others are working on. So finally, in our last few minutes, there is a few City of Portland ordinances that are worth knowing about, and these apply relate to facial recognition technology. So there are two ordinances that were passed by the mayor and the city council in September. The overarching concern was to address privacy and intrusiveness, over surveillance, lack of transparency, and gender and race bias that was sort of thought to be inherent in these technologies. So in a press release, Mayor Wheeler discussed use of facial recognition technology to harm civil rights and civil liberties of Portlanders, with specific reference to discrimination against people of color. The first ordinance went into effect immediately upon signing on September 9th. That ordinance bans the use and acquisition of facial recognition technologies by city bureaus. There's limited exceptions. So staff can unlock their iPhones or other devices using facial recognition. There's also a limitation in certain social media contexts, which is governed by a separate social media policy that the city has. And then you can also use facial recognition for redaction purposes. So to remove things from, identifying information from certain videos before they're used for public purposes. And the second ordinance goes into effect January 1st, 2021. And this applies it could apply to folks on the webinar today. It bans private entities from using facial recognition technology in places of public accommodation and will be inclusive of all private entities in Portland. So it's a City of Portland ordinance, so it applies to the City of Portland. Places of public accommodation are any facility, public or private, that are used by the public. Restaurants, bars, stores, recreational places, public gathering places, gyms, movie theaters, lots of those places none of us are going to right now, but of course this will be in effect hopefully when we can all get back together again. The ordinance does not include commercial facilities operated by private entities, private clubs and religious organizations, private residences, or places of accommodation that by their nature are distinctly private. That is it. I know it was a lot of information. If there are any other questions, we have just 1 minute until 1 o'clock, but I'm happy to stay on for a few extra minutes if others have questions. Just give it a second if anyone wants to type. Otherwise, we really appreciate you taking the time today. I know it's a lot of information and there may be follow-up questions, and if you have them, I'm happy to connect with you on email or feel free to call. And we will continue to keep you updated on the status of privacy legislation as we learn more and as things change, and certainly if there's any movement on the federal level. Thank you, everyone. I think that's all for now. Take care and have a great day and happy holidays and happy new year. Looking forward to 2021.